Uno, dos, uno, 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 uno. No, si toca estárselo. Uno, dos,
Uno, lejos. Uno, dos. ¿Se suena?
Yeah, so let's just give me All right, good morning, everybody. Just a bit of housekeeping. If you look at your desk, there should be an earpiece that you can put in your ear for translation. There are two buttons right there just under the digital screen. If you press the second button that will be on your right and you go to 2, that will be the English translation. If you go to 5, that will be the Spanish translation. And if you go to 1, then you will hear whatever language the person on the mic is using at that moment, okay? So I'll go over it again. Just under the digital screen there, there's a black digital screen. You press the buttons there, it will illuminate. 1 is for the floor, 2 is for English, 5 is for Spanish. Okay. 5. Okay.
Ah, Max Mana. Oui, Mana Max.
Yeah.
The Miraculous Court of Human Rights is now in session. In the matter between All Lives Matter and the State of Legacy, the Honorable Judge Veronica Gomez presiding.
All right, you may be seated. Welcome everybody to the 17th edition of the Nelson Mandela World Human Rights Moot Court Competition. Before we start, I'm just going to give you a brief introduction of the judges who are constituting the bench for today. We have Mr. Yashivi Nain. Mr. Yashivi Nain is an international human rights lawyer who is currently serving as a human rights advisor at the permanent delegation of the Commonwealth to the United Nations in Geneva, where he supports member states, particular SIDS and LDCs in engaging with UN rights mechanisms, including the Human Rights Council treaty bodies. Prior to this, he led international advocacy at Commonwealth Human Rights Initiative and has extensive experience working on key human rights issues, including migration, statelessness, and refugee law, gained through his roles at the Office of the United Nations High Commissioner for Human Rights and the United Nations High Commissioner for Refugees. Mr. Nain holds a BA and LLB degree from Rajiv Gandhi National University of Law, India, and a master's in law from the Geneva Academy, where he was a Hans Wilsdorf scholar. We also have Professor Thompson Chengeta. He is a professor of law at the School of Law, Liverpool, John Moores University, appointed in 2024, an expert on autonomous weapon systems, AI ethics, and drone regulation. He currently serves on the International Panel of Regulation of Autonomous Weapons for Africa with the campaign to stop killer robots. He is the principal investigator of the African Commission on Human and People's Rights, study on human rights, implications of AI, robotics, and emerging technologies. He was appointed to the UN Secretary General's Advisory Board on Disarmament Matters and is a legal expert and advisor for the International Committee for Robot and Arms Control. Next, we have Manfred Novak, who serves as a UN Special Rapporteur, on torture from the year 2004 to 2010, leading missions and major reports, including on Guantanamo. He is the Secretary General of the Global Campus of Human Rights, a position he has held since 2016, and is the Scientific Director of the Vienna MA in Applied Human Rights. He is also the co-founder and former co-director of the Ludwig Boltzmann Institute of Human Rights in Vienna. Professor Novak was also formerly a judge at the Human Rights Chamber for Bosnia and Herzegovina, UN expert on enforced disappearances from the year 1993 to 2006, and the independent expert leading the United Nations Global Study on Children Deprived of Liberty. He was also a member of the International Panel of Experts adopting the Yogyakarta Principles on the application of international human rights law in relation to sexual orientation and gender identity. We also have Judge Veronica Gomez, who is a judge of the Inter-American Court of Human Rights, and is currently serving her term from 2023 to 2028, elected by the Organization of American States in November 2021 and sworn in 2022. She is also president of the Global Campus of Human Rights and director of the education at Centro Internacional de Estudios Políticos, which is the International Center for Political Studies, at the Universidad Nacional de San Martín, located in Buenos Aires. She had an extensive tenure at the Inter-American Commission on Human Rights, where she served as a principal specialist between 1998 and 2009, contributing significantly to the Commission's work in the Inter-American human rights system. We also have Judge Ivana Jelic, judge at the European Court of Human Rights, elected in respect of Montenegro in July 2018, with a term expected to run up until 2027. She has been Vice President of the Court since 1 November 2024 and has served as President of a section since July 2024. She previously served as Associate Professor at the University of Montenegro from 2012 to 2016 and Vice Chair from 2014 to 2016 of the Advisory Committee on the Framework Convention for the Protection of National Minorities, Council of Europe. She also was a member and Vice President of the United Nations Human Rights Committee, a member since 2015 to 2018, and Vice President from 2017 to 2018. Finally, we have Mr. Simon Walker, who is an experienced human rights lawyer and international civil servant. He currently serves as Chief Rule of Law and Democracy Section in the Office of the High Commissioner for Human Rights, leading a team of experts covering administration of justice, counterterrorism, and human rights, abolition of the death penalty, drug policy, and human rights in detention, media freedom and safety of journalists, democracy, transitional justice, and human rights in armed conflicts. Previously, he was Chief Section 1 of the Human Rights Treaties Branch from 2011 to January 2022 and was representative of the Office of the Human Rights High Commissioner for Human Rights, Cambodia. This, ladies and gentlemen, constitutes a very well-experienced bench in the field and very relevant to the facts of today. Without further ado, I hand over to the bench.
No microphone for the speaker.
So good morning. We open this hearing of the Boropolis Court of Human Rights in the matter of All Lives Matter and the state of legacy. We will start with calling the parties for an introduction and to indicate how they're going to allocate the time between the oralists. So empezamos con los demandantes.
So let us start with the plaintiffs. If we can pass the floor to the plaintiffs' party for them to introduce themselves and tell us how they're going to allocate their time.
Honorable Tribunal.
Honourable bench. Our team comprises plaintiff Emily Pedasa and Santiago Fuentes, myself. We will allocate 20 minutes to each speaker and then we will retain 3 minutes for right to reply.
Muchas gracias. Now the respondent team, could you please introduce yourselves and indicate the distribution of time?
Madam President, Your Excellencies, may it please the court. We appear on behalf of Legacy, the respondent in this matter, and my name is Watson Somerai. With me is Michelle Chiwanga. Our time allocation will be as follows. The first oralist will utilize 23 minutes, and the second oralist will utilize 22 minutes. Thank you.
Thank you very much. Therefore, now we call on the applicant to present its argument. Le pedimos, por favor, a el demandante que presente su argumentación.
Muy buenos días.
A very good morning. On behalf of those representing our collective victims, we'd like to extend a cordial greeting to the Honourable Bench of the Court of Bureaupolis, to staff, the court, translators and those others present in this room. More than a year ago, Gustav Cook and 900 asylum seekers fled desperately from their countries, seeking in legacy an opportunity to live. Instead of finding that, they were incarcerated. This is why we are here to represent those victims, and we will be responsible for demonstrating, first of all, the admissibility of this petition and the jurisdiction that you have, Honourable Court, to hear it. Secondly, we will tackle the international responsibility of legacy pursuant to the violations deriving from matters 1, 2, 3, and 4 before this court. The first question being how the elements concerning admissibility will be tackled, and 2, 3, and 4 will be tackled by my co-plaintiff, Emily Pedras. Finally, we will deal with reparations that we will be requesting, and we respectfully submit our petition subsequent to that. First of all, dealing with admissibility. If you look at the factual threshold for this, we will be basing this on the Afropolis Human Rights Court, and we will be demonstrating how a claim concerning the lack of exhaustion of domestic remedies under the Afropolis Charter is relevant to this.
My apologies. Maybe before you deal with the question of admissibility, I just have a question regarding jurisdiction, particularly in relation to claim number 4. And the question is as follows. Is this court competent to assess the legality of a unilateral sanction or countermeasure? And if so, by reference to which applicable legal framework? In other words, is there any precedent where a regional human rights court made an assessment of the legality of unilateral sanctions?
Vinculada a la cuestión número 4.
And question 4, we would sustain that if you look at Article 8 of the European Convention on Human Rights, sentences such as Glock against Switzerland have established that the 8th article, private life and family life, includes the right to health, physical integrity, moral integrity, and generally speaking to well-being. And to specifically answer the question concerning the precedent, sentences such as Nader against Switzerland have also established that in situations of an economic nature, these have a serious potential for violating human rights. And on substantive issues, we will demonstrate that the measures we are upholding are coercive measures of a unilateral nature which have specifically violated the rights under Article 8. Before continuing with the other elements, in order to return to the points on the exhaustion of domestic remedies, we'd like to emphasize that domestic remedies have that as available in the Republic of Legacy have indeed been exhausted. The constitutionality of the law on migration has been questioned. The legal order that overturned has violated the rights of our clients. Under Article 32, it is demonstrated that Gustav Cook, both at first and second instance courts, had the right to residency upheld, and well, there are claims that there are still resources to be exhausted in terms of domestic remedies, we would sustain that those remedies lack a significant element, which has been demonstrated in jurisprudence. That is availability. Communications such as the African encounter against Zambia demonstrated that where we have persons deprived of their freedom in a state prior to deportation, they cannot be expected to exhaust any additional domestic remedies, and therefore any judgment in contrary would be disproportionate. Now, in terms of jurisdiction, the factual basis of this will be based on the European Framework for Human Rights, and this is the way.
Just back to the point that you have addressed about unavailability of local remedies. The jurisprudence which you have referred, the same African Commissioner has reiterated the aspect that there cannot be speculation about exhaustion of local remedies. Claims that simply perhaps it will not succeed is not sufficient. What would be your comment on that?
Claro que sí.
Yes, indeed, Honourable Judge. We would like to say that in jurisprudence as that we've cited or in other cases, relating, for example, to the Cortes Frances against Sudan case, this cannot be applied to people in a particular situation of vulnerability expecting deportation. It is unreasonable, therefore, to require of them to continue to exhaust domestic remedies. This is contained in Article 56.5, and we'd like to emphasize that sentences such as FIDH against Senegal have also established that it is also not appropriate to require the exhaustion of domestic remedies when we are facing collective violations. Under item 1, we will demonstrate that these claims should not be individualized against each of our clients, and we are in the context of a collective violation of human rights. This brings us to an extremely important point, and that is to demonstrate ratione personae jurisdiction. Questions have been raised concerning our ability to represent 900 asylum seekers as individuals, and that we should enjoy further authorization in order to do so. But we would like to refer to a case against Ethiopia, where it was established that NGOs who are defending human rights, as has been the case in these previous cases, can present petitions on behalf of third parties without further authorization when they are not in a position to do so themselves. And that is why, Honourable Court, that we would respectfully request that the court consider our ability to effectively represent the 900 claimants. This line of argument.
May I ask you something? Yes, we understand that your NGO is representing Gustav Cook and 900 detained persons in depot. My question is about the standing of your organization in terms of climate migrants, because for climate change issues, there is a standard set forth by the European Court of Human Rights in Klima Senior and Schwarz versus Switzerland. Do you think that three-step test is important here, that it is actually to be applied? And if so, could you justify a standing, local stand in this regard? Thank you.
Claro que sí,
Yes, indeed, Honourable Judge. We want to first of all provide a clarification. Our only argument for requiring the finding of a violation, of a non-violation in line with Article 1, isn't only in relation to climate issues. Nonetheless, we would like to propose to the Human Rights Council of Bureaupolis that a jurisprudential dialogue is conducted here with both the African Afropolis system and the African system as regards climate rights, there are existing instruments such as the Cartagena Declaration already, which recognize that it's important to protect those in a particular situation of vulnerability in these regards. And I cite when they are located in other circumstances which have already affected public order. This last element has already been interpreted by the Inter-American Human Rights Convention. In its resolution 2 of 2024, it established that the impacts of climate change, including socio-environmental disasters, can profoundly impact the life, security, and freedom of plaintiffs. In the same way, in a parallel context in the African system of human rights, there were specific arguments brought by the African Unity Movement in the rulings concerning that in Article 2.2, they upheld the principle of safeguards in this area. And we would argue, therefore, given the global parameter of the European Human Rights Convention, it's established that not only they can, but they must take into account developments at the international level when interpreting the convention, and that this be taken into account along with past jurisprudence when we rule against the state of legacy for violations with regards to item 1. Honourable Court, to date we have demonstrated the admissibility of the petition and the jurisdiction that the court has to hear it, both in ratione materia and ratione personae. We will now get into issues on merits, beginning with item 1, where we allege that first of all, we've had a violation of Article 4 of the 4th Protocol of the European Human Rights Convention, which prohibits collective deportations, as well as the principle of non-refoulement as regards Articles 2 and 3 of the Convention. Equally, there's been a violation of the right of personal freedom of those being represented. We will then move on to analyse elements related to the migratory situation around Gustav Cook, beginning with collective deportation of 900 asylum claimants.
Counsel, my apologies. No, sorry, it's all right. My apologies. Before you go into the details of the merits, I just said one last question on the question of admissibility of claims, in particularly claim number 1. Please, can you clarify what exactly is the basis why you're arguing that this issue is admissible? If I'm to be more clear on my question, I suppose the question is whether there has been an attempt at the local level to exhaust local remedies. If you look in terms of paragraph 33 and paragraph 34 of facts, the applicant, that is yourself, before this court did not even know that another litigant, that is We Are the World, he had filed a petition before the respondent's court. On what basis, for example, that's my question, on what basis can the applicant, for example, claim that there's been an attempt to exhaust local remedies, particularly regarding claim number 1?
Honorable Juez.
Honourable Judge, 2 extremely important points in that regard. First of all, the appeal around unconstitutionality, which was submitted by We the World, was resolved against them, and that was submitted before this case. Secondly, communications such as that from Dr. Ibrahim against Sudan clearly established that exhaustion of extraordinary remedies cannot be requested before appeal to the regional human rights courts, and that is why that appeal, which was submitted for the second time by a different NGO, is still unresolved, and that is not a legitimate reason for this court not to be able to hear honourable judges this case. Now, to return to issues on the merits, we want to continue with the first point, the collective deportation of 900 asylum seekers. I want to emphasize that cases such as Palais against Italy have established that the intention to deport a group of persons in their capacity as a group without individualizing each one of the members of that group is by definition a collective deportation measure which is prohibited by the European Human Rights Convention, and this is what has occurred with our claimants. We have not seen account being taken of the reasons for their asylum claim, their specific countries of origin, nor the specific dangers they will run if they are deported. And this has profound connection to the principle of non-return. Article 33 of the Geneva Convention, 1951, establishes the principle of non-return, declaring that you can't deport somebody when they run the risk of their freedom, life, or the possibility of being subject to torture. And there are obviously many cases relating to this. The case of the children in this group in Article 30, it establishes that among these 900 people include children. It has been established that in Chitari Republic, they have the practice of child soldier recruitment in certain violent gangs. And so those children will clearly run the risk of being recruited. That is against the principle in Articles 2 or 3 of the European Convention of Human Rights of non-deportation. In addition, honourable judges, more than a year ago, our claimants were deprived of their freedom despite the fact that the decision had already been taken to deport them. In line with Article 5 of the European Convention, in subparagraph F, it establishes an exception to the right to personal freedom when deportation of an individual is being carried out. This is true nonetheless. Rulings such as NMB against the Netherlands established that this cannot be done in an arbitrary fashion. And we would claim that there is no reason for these individuals to have been incarcerated without their situation being taken into consideration. In cases such as R against France, the French state was found responsible for having detained somebody for 4 months, and we're talking here about a year. And this is a similar detention condition. This is therefore not justifiable in this particular case. We also would like to emphasize that there has been a violation of the prohibition of non-discrimination as regards the right to effective remedy. Sentences such as Kennan against the United Kingdom demonstrate that effective recourse should have the following characteristics: accessibility, availability, effectiveness, rapidity, independence, and impartiality. Taking stereotyped decisions when deciding about resources and asylum claims violates rulings such as MES against Belgium and Greece, and that in particular regards to the character of effectiveness. Fact 29 demonstrates that these individuals are being denied these rights because of their capacity as Afro-Polis citizens, and this directly violates these human rights principles. If legacy is demonstrated to declare suspect states as such, this violates Fact 20. This relates directly to Fact 29, when words such as savages were used to stereotype people from Afropolis, and this clearly demonstrates a discriminatory position, which means that people, because of their race, are being deprived from access to an asylum process. Honourable Court.
Sorry for another question. Just 2 questions that I need clarity from you. In terms of paragraph 25, we are told that approximately 8,000 people have died. Perhaps someone can say on account of perhaps lack of rules in the immigration of the respondent state. That's why they then respond with the act that they then enact. Then in paragraph 30, we are hearing that 900 asylum seekers are the ones who have been affected. Do you think that there is a tension here for this court to balance between the right to asylum versus the right to protect life? We actually have numbers here of people actually dying in numbers because of lack of perhaps protection of our borders, as it were. My second question, and this will be the last, is that I hear the argument, counsel, that you are making about discrimination of people coming from certain countries here. But do you think that there is a bigger picture that we could look at here in terms of brain drain that was happening, where critical skills from these poor countries actually being taken in? And now that this is actually being stopped by this immigration policy, isn't that a good thing for this developing country or this poor country?
Honourable Judge, with regards to the first question, it's true that legacy, because of the terrorist attacks which took place in the capital, may take particular care with those entering their territory, but this does not exonerate it from its obligation to individualize each of the asylum claims. And this is demonstrated by rulings such as Khalifa and others against Italy. And what's being demonstrated in item 29 is that the requests from the Afropolis people are being declined for the mere fact that they are from Afropolis. Anybody coming from Chitari and the Republic of Armada, in the words of the President of Legacy, are terrorists, and this is not admissible. In relation to the second question, Judge, it's true that both in Chitari and the Republic of Armada, there is a profound crisis of violence and internal displacement. And we submit ourselves to arguments related to climate refugees as well. We cannot condemn these individuals to be able to survive or live through these conditions, denying their right to seek asylum for these reasons. Another element is that, pursuant to the principle of international cooperation, Legacy is allowing is allowing the situation to develop, or should allow the situations to develop in Chitari and the Republic of Amara so that people can remain there. But this has not been done. On the contrary, actions have been taken to worsen conditions in those states. Honourable judges, I would now beg to close the current representation on behalf of the claimants, and I will pass the floor to my colleague who will deal with claims 2, 3, and 4, as well as reparations. For now, I would like to thank you for your attention.
Moralista 2.
Once again, on behalf of the victims' representatives, we would like to extend our warm greetings. I would now like to continue our intervention regarding the other claims. Claim number 2, technology. 3, gender identity. 4, unilateral coercive measures. And finally, reparations and list of requirements. As regards claim number 2, in line with paragraph 21, the State of Legacy has promulgated its new law on migration, and in its article number 8, it has authorized the use of monitoring systems, including autonomous algorithmic monitoring and processing of asylum claims. We would like to clearly demonstrate how this violates Article 8 of the European Convention on Human Rights, the right to private life. The ruling of the European Court of Human Rights, Big Brother Watch against the United Kingdom, demonstrated that when there is interference in the right to a private life, this must comply with 3 requirements. Must be in line with the law, it must have a clear objective, and there must be necessary and proportional rationale in the context of a democratic society. Honourable Judge, this same ruling also stated that as regards legality, a law must be clear. That is to say that it must determine the facts to which a determined legal consequence must be assigned. Nonetheless, despite the Legacy First Migration Law and its authorization of the use of monitoring systems, they have not ensured this characteristic is therein contained.
Please, do you want to claim that foreseeability is a problem here and also legal certainty? Because when you are talking about the Big Brother's Watch and Article 8 violation, I think that you should also tackle these issues. Thank you.
Just a request for the interpreters. Would it be possible to make these claims seated so we can hear properly? The speakers are standing up and quite removed from the microphone. If not, we will do our best. There is legal uncertainty because we have to look at the legal consequences for appropriate data processing. More specifically, This law needs to define clearly the activities. Our list, the interpreters would really appreciate it if you could sit down, yes, because you're very far removed from the microphone. We very much appreciate that. Thank you. And then we can, yes, when they stand up, they're quite far removed from the microphone. So thank you very much for passing on that, Madam Chair. Judge, rather. Just going back to my arguments on this, the legal uncertainty is there because it needs to clarify, first of all, very precisely, the activities, the intelligence activities, and how that impacts on personal data. And as has been said by the good practice document to guarantee human rights by the intelligence services. In other words, you need to specify the category of individuals and the activities where you're going to collate data and describe the functionalities in processing personal data. And this takes us on to the next claim, the legitimate purpose. The state agency in this regard is acting under 8.2 of the European Convention of Human Rights. National security, that's what's being invoked. But the above mentioned sentence says that technology can be a tool if there is a serious threat, such as terrorism. Notwithstanding that, that cannot stray into arbitrariness. There needs to be proportionate measures taken as part of a democratic society. This ruling shows how such principles, particularly the 108 Convention on Protection of Data Protection, should be applied, particularly Article 7 of that, principles of security of information, which allude to the fact that the state must adopt administrative, technical, and human measures which enable personal data protection. The explanatory part to that convention talks about certain pillars regarding this: integrity, availability, and particularly confidentiality. Distinguished judges, in line with this case 30, there has been a violation of this requisite, which is confidentiality. Initially, there was unauthorized access to this, and even worse than that, there was an online leak of biometric registers and records, not any record, but sensitive records, which have to do with the information of a particular individual. Somebody who accesses that information, they may well be victims of discrimination, because we are talking about personal data of migrants. Therefore, a violation of Article 8 of the European Convention on Human Rights. Allow me to press on with 3. In line with the facts, do apologize. Applicant, could you enlarge further on this notion on proportionality? Because this indeed is one of the tools and arguments used by the state, where they say it is justified to take these measures because of security issues. I'd like to know how that is different to anything else where there is access to specific information to an individual. So I'd appreciate it if you could enlarge a little more as to why you think this is not proportionate. Honourable Judge, there is a clear goal. And once that's identified, I think it is clear to see the need for technologies. However, proportionality talks about the Convention 108 on protection of personal data, and more specifically measures such as upholding human rights since the very design right up to the technology use itself, which means even from the very outset when the creation of these technologies, one needs to take into account what data is being processed and used, having proper monitoring measures for these algorithms, and establish what systems can be in place to ensure that there are some sort of safeguards, such as privacy, authentication measures, encrypted data, etc. Could I continue now, moving on to 3, in line with the facts of the case?
Can you a little bit clarify the second bit of the question, how autonomous algorithmic processing of asylum and refugee claims violate fundamental human rights? I think I've heard you on the question of technological surveillance. I'm not understanding on the autonomous algorithmic processing. If you may please clarify how that is inconsistent with human rights, please.
And also, if I may also ask a follow-up question on the question of proportionality, don't you think that considering the recent events like the bombing act and the fact that a lot of refugees are coming from the neighboring countries, and we have also seen the fact that because of all these refugee influx, there is an economic crisis also. The state of legacy is putting a lot of money in the neighboring countries, and billions of dollars have been spent. So don't you see from the point of the states that their resources are also constrained, and for the safety of their people, it's proportional, the act of using AI and algorithm to determine the refugees who are coming, is it not proportional from that point of view? Thank you.
Honorables jueces.
Well, Your Honours, it's not proportionate, and particularly it provokes discrimination. If you look at the various elements that make up these automated decisions, data collection, the type of learning as well, and the results of this, in line with the European Convention on Human Rights, particularly 108, protection of data, personal data, there's a very important principle in line with the Special Rapporteur's report 5668, which has to do with discrimination, contemporary forms of discrimination. In that report, it says that they mustn't underrepresent or be incomplete vis-a-vis certain groups of individuals. Case 29 illustrates how, well, you have this facial migration repository, and a quarter of the migrants coming from Andai, which generates discrimination because of this bias that occurs because of the fact that there isn't remaining data relating to this. Your Honours, I think, and you mentioned this, there is this, the Watch versus UK, but that mustn't mean that that overrides our argument on arbitrariness. And you see how Legacy issued an executive order recognizing strictly the masculine and feminine sex, that is all. And Gustav Cook, who was a transsexual woman, was put in a male prison. Your Honours, I think this clearly violates the right to gender identity in line with the right to equality and avoiding abuse. I'd also like to refer to 2 further points. First of all, indirect discrimination via what is known as prejudice-based violence. And secondly, what do we understand by being a woman in line with the international system, and particularly in line with the European human rights system? On the first point, the European Human Rights Court ruling, Biao versus Denmark, indicated that there can be indirect discrimination when we're dealing with a neutral criterion. However, it can be substantially harmful when we're talking about a comparative reference. And in that regard, judges, the executive order might appear to be neutral. However, it has clearly harmful and prejudicial impacts on transsexual persons as opposed to cisgender.
I would like to ask you about 2 aspects in terms of gender equality protection, which is relevant here. So one angle is Article 8, and you already elaborated on this, but I would like to draw your attention to human dignity in this context. and jurisprudence, not only on the human rights, on the European Court of Human Rights, but also treaty bodies of the United Nations. But also what I would be interested here is Article 3 of the European Convention on Human Rights aspect. So the balance must be struck between public interest and the private rights in transgender individuals regarding detention. We could talk about different levels of Article 3, like degrading treatment, cruel, inhuman, torture, etc. But how do you evidence imbalance in order to prove that Legacy's policy on gender identification is inconsistent with international human rights standards? Thank you.
Council, if I may add a question. Would you think that there's an obligation of states to provide a separate prison wing for transgender persons, in this case, a transgender woman?
With a microphone, please.
Honorables jueces.
Your Honours, initially, regarding Article 8 of the European Convention on Human Rights, there's the Christine Good versus the UK ruling, which says that one has to guarantee and protect the right to a gender identity. And the second point in my submission, I will say more about how you prohibit ill treatment, but more specifically, once you have this indirect discrimination, according to the independent expert, to protect against violence based on gender identity. This was a recent report, the 17th of April 2025, and in that report, it talks about how the transsexual population suffers from more aggravated violence, sexual and psychological violence. And that is clearly violating Article 3 of the European Convention on Human Rights. Honourable judges, on the second part, the inter-American system of human rights has already addressed cases in this regard since the ruling Hernandez against Honduras, and also the advisory opinion 29 of 2022. In addition, judges, if you were to separate the transsexual population generally, you would be creating a discrimination by doing that based on gender. In our representation, what we're saying here is that each and every individual be consulted who's intervening in this process, because they were not, Gustav Cook was not able to have a voice in the matter. In similar vein, if you have indirect discrimination, I'd like to move on to the second part of my arguments. What does it mean to be a woman in the 21st century? It's incredible that in this century we are reducing women simply to their sex. If you look at the Committee on the Convention and for the Elimination of Discrimination, Women, Recommendation 35, say that women have various gender identities. And this is something that is in SD against Italy as a ruling which flagged that it is an illegitimate requisite to have somebody submitted to gender reaffirmation or gender reassignment surgery in order to have their gender recognized. 26 as a case shows that you have this executive order tantamount to indirect discrimination, ignoring Gustav Cook's identity, gender identity, putting them in a very hostile, dehumanizing environment, leading to harassment and abuse, as well as mockery and taunting.
Apologies. Do you perhaps think on this very important point that you're articulating, that there is a need for relativism In other words, paying attention to each region, culture, nation's own approach, and therefore allowing states some sort of margin of appreciation. I'm just trying to say this court, can it look at what exactly is happening around the world and say, on issues of this nature, perhaps it is better left to the state to determine. In other words, balancing of interests here between cultures, state interest versus individual rights. What would be your comment on that?
Again with the microphone, please. Thank you.
Un punto en el que muestra
Something which illustrates how this discretion of the state, and this goes back to an EU ruling in 2014, this is now very reduced in nature, because here we're talking about identity and the protection of an individual. Therefore, it cannot be left up to the discretion of states for all the arguments I have set out. On claim 4.
My apologies for following up on that question. I'm not merely suggesting leaving this to the discretion of the state, but the state as a representative of a particular nation or a particular culture. My question is, can there be a tension between individual rights versus collective rights of a people in this particular regard?
Honorable juez, como
Your Honours, as I said earlier on, the inter-American human rights system has addressed this issue under the interpretive rules of the European Union. There needs to be account taken of jurisprudential development in the Inter-American Court, which is the opposite party there. This is not just a question between the tension between collective and the individual. The request is for dialogue. Everybody intervening in the process needs to be included so that their gender identity can be accommodated.
Le pregunto.
I have a question. So what you are arguing, therefore, is that in the inter-American system, people deprived of their liberty can, on the basis of self-identification or self-perception of their identity, can decide what sort of regime of deprivation of liberty they should be under. Is that what you're saying? Is this your argument? I'll try to answer your question, and I would just request 2 additional minutes. If I can have 2 additional minutes, yes, you may have those extra 2 minutes, and that will be taken into account regarding the respondent speaking time as well. The advisory committee, which I've already mentioned, said that, yes, the transsexual population needs to be consulted regarding the center of detention which they wish to be kept in order to comply with these obligations in the area of equality, gender identity, and prohibiting ill treatment. As regard petition 4, the facts show how Legacy issued unilateral coercive measures. And if you look at the European Court of Human Rights, against Switzerland affects human rights, particularly Article 8 of the European Convention, because of its illegal nature. Again, this emerges from the Special Rapporteur on Universal Coercive Measures number 4859, indicating that one can identify these when they are issued by the state without authorization from the Security Council, therefore violating their international obligations, particularly in order to affect the behavior and policy of states with if there is not any retaliatory measures taken. And I think in that case you can see, if you look at 15 and 70, how the Legacy state used its position as a former colonizer of other states and a powerful state itself, as per the Inter-American Convention on Human Rights. Once those violations are identified, there needs to be full reparation for victims, in this case, Gustav Cook. Thanks to the Campo Organized against Mexico case, there needs to be a transformative opportunity to ensure that there is an end to discrimination in legacy state. In other words, to create a specialized protocol regarding the transsexual population, respecting standards that I've mentioned already in the brief. Thank you.
Gracias.
Thank you. Thank you to the applicants.
To the respondent state. Please take the floor.
Madam President, Your Excellencies, may it please this honorable court. In direct response to the applicant's submission, we'll respond as follows. With respect to jurisdiction, we'll establish that the applicant has failed to satisfy the victim requirement in terms of Article 34 of the Bureaupolis Convention on Human Rights. Secondly, that claim number 4 does not fall within the ambit of the material jurisdiction of this honorable court in terms of Article 32, subparagraph 1 of the Bureaupolis Convention on Human Rights. On admissibility, we'll submit before this honorable court that the applicant has failed to exhaust domestic remedies and that it has failed to meet the applicable exceptions for the waiving of this requirement. And under the legacy immigration policy, we'll submit that there was no violation of rights, rather a justifiable limitation in terms of the law. I'll now turn to jurisdiction. Having invoked the European Convention on Human Rights as instructed by paragraph number 10 of the Statement of Facts, the applicant had a burden to establish the jurisdiction of this court in terms of personal jurisdiction pursuant to Article 34, as well as material jurisdiction pursuant to Article 32. One of the key features for material jurisdiction under Article 34 is that the applicant must demonstrate that they are a victim before this honorable court. And the European Court of Human Rights, in the case of Class and others versus Germany, stated that a victim is one that is directly affected by the alleged violation, and it does not suffice to claim that there is a violation merely on the basis of the existence of a law. From a reading of paragraph number 34 of the Statement of Facts, it is clear that the claims are brought with the victims in mind, and the victims being, among others, the 900 asylum seekers and Gustav Cook. Which brings us to the next element. Are there any applicable circumstances where non-governmental organizations may represent victims before this honorable court?
Counsel, I appreciate your arguments in respect of victim status and the case law of the European Court of Human Rights in this regard, especially emphasis on a direct causal link. But there are situations in life, like being a refugee, the context, the conflicts, climate change, etc., which are of wider importance. And according to international law, not every claim has to be justified in terms of concrete victim status if the context is different. Do you think that there is jurisprudence which is contrary to your statement? And do you think that each of 900 individuals, including children, should have a proof on a direct causal link, or the context, which is evident here, is sufficient? Let me remind you that the Convention on Refugee Status and interpretation by international organizations could speak a little bit in a different direction when we talk about the individual claims and the wider context. Thank you.
Excellency, indeed there exists jurisprudence by the European Court of Human Rights contrary to the requirement of the victim status, particularly the case of Center for Legal Resources versus Romania, where it was stated that there are exceptional circumstances when organizations may represent victims. However, A reading from paragraph number 101 to 105 of that case underscores that the exceptional circumstances which were accepted in that case are quite different from those that we have in the present case. However, Your Excellencies, we do understand that in terms of Article 32, subparagraph 2, particularly due to the competence, dealer competence principle, this honorable court has the discretion to determine the limits of its own jurisdiction. Therefore, I will now proceed to the material jurisdiction aspect, particularly to the fourth claim. Your Excellencies, the fourth claim, from the way that it is worded on paragraph number 34 of the Statement of Facts, deals with the legality of unilateral sanctions. And we submit that this goes beyond the mandate of this honorable court. As appears on paragraph 10 of the Statement of Facts, this honorable court is a human rights court, primarily there to interpret and apply the provisions of the Bureaupolis Convention on Human Rights. And the European Court, in the case of Al-Dolimi versus Switzerland, underscored that the European Convention does not confer upon the court any power to declare in abstract that a given act or measure is unlawful under international law. What the applicant is therefore required to do in order to bring this claim within the purview of the jurisdiction of the court is to establish that there exists a nexus between the unilateral declaration of sanction and violation of human rights, which are guaranteed by the Bureaupolis Convention on Human Rights, and the applicant has failed to do the same. With respect to admissibility, as appears on paragraph...
Maybe, Counsel, but before you go to the question of admissibility, this point that you're addressing, I'm wondering, is it not possible within the powers of this court for the court to assess the human rights implications of unilateral sanctions without necessarily engaging their broader legality under general international law? In other words, we just keep to the implications to human rights of these particular measures without actually trying to decide their general legality under international law. Would that not be within the jurisdiction of this court?
Indebted for that question, Your Excellencies. Indeed, particularly upon reference to the case of Bosphorus Airways versus Ireland, it was stated that the European Court, which is substantively similar to the present court, does have the power to determine the implications of measures by state in as much as they relate to human rights. The point that Counsel was just trying to make is that the applicant had failed to establish such nexus before this honorable court. Now, with respect to admissibility, Your Excellency, the applicable criteria in terms of paragraph number 10 of the Statement of Facts is that of Article 56 of the African Charter on Human and People's Rights. And we submit that of the sevenfold requirements, Article 56, subparagraph 5, which provides for the need to exhaust domestic remedies, has not been complied with in the present matter, and will proceed to place the submission in context. Your Excellency, with respect to paragraph 31 of the Statement of Facts, it is apparent that the applicant only made a petition regarding the constitutionality of the Legacy First Immigration Act, which was duly dismissed by the High Court. However, with respect to the claims of gender identification, the claim of the unilateral declaration of sanctions, and the claim of surveillance, it is evidence from a reading of the fact sheet that these were never brought before the domestic courts in Legacy. Now, we do understand that the applicant may be tempted to rely on paragraph 33 of the facts, which provide that there is a pending application before the Supreme Court by a separate organization called We Are the World. And the said petition was filed in 2022, which is 3 years ago, and it is yet to be determined. However, we implore this honorable court to draw inspiration from the case of Chacha versus Tanzania, where the African Commission on Human and People's Rights underscored that if there is ever a prolonging of remedies, then the question as to whether the said remedies have been unduly prolonged is an objective question which must take into account all applicable circumstances. Now, at this point, I'll respectfully draw the court's attention to paragraph 6 of the statement of facts, which provides that the Supreme Court is an exceptional remedy, not an ordinary remedy. Now, in the case of Marius versus Cote d'Ivoire, it was said that there must be an attempt to exhaust the ordinary judicial remedies. Now, the High Court was available, and its effectiveness has already been demonstrated by the August 2024 constitutional petition. Why the applicant therefore decided not to approach the same court with respect to other claims has not been justified before this honorable court. And in the case of Article 9,
Counsel, perhaps before you proceed, I'm not following on the justification of the delay, the 3 years that you have mentioned. What is the justification for that delay?
Most indebted for that, Your Excellency. The justification of the delay is better understood by a holistic appreciation of the statement of facts. Where did We Are the World file their constitutional petition? The Supreme Court. Now, what is the Supreme Court within the state of legacy? Paragraph 6 said that it is a court that exists as a special remedy. Now, what is the test applicable for domestic remedies? Jawara versus the Gambia states that only judicial remedies must be exhausted, and these must be the ordinary judicial remedies. The remedy which was sought after is not the ordinary remedy, but the exceptional remedies. Pursuant to the case of Chacha versus Tanzania earlier cited, in assessing now whether the delay was undue, there is need to come up with a broader context, analyzing all the applicable circumstances. Since the fact sheet is silent with regard to the reason behind the delay, perhaps it can be reasonably inferred, Your Excellencies, that the reason why there is such delay is because the remedy itself that was sought is an exceptional remedy, not an ordinary remedy. Particularly if we then juxtapose the exceptional remedy with the ordinary remedy, such as the High Court. Paragraph 31 of the facts shows us that where the High Court was invoked, the matter was resolved timelessly and a decision was made. There is no reason why the applicant could choose not to approach and exhaust those ordinary domestic remedies.
I hear your point, Counsel, but if I'm to go with the same inference that you are invoking, if the Supreme Court here is an exceptional remedy as you are implying, doesn't this suggest then that perhaps it's not faced with too many cases, since no one ordinarily go there? And if that's the case, wouldn't you then accept that maybe it has fewer cases and then decisions should be quickly made?
Thank you for the question, Your Excellency. Indeed, there is a possibility that the Supreme Court does not face a lot of cases. However, what is imperative is to understand that in taking into account domestic remedies, the procedural aspects governing the domestic court are also relevant. However, since we have not been furnished with the same in terms of the statement of fact, we would concede to the wisdom of the court, basically referencing the case of Egyptian Initiative for Personal Rights, where it stated that procedural requirements must not be interpreted in a way that then ultimately defeats the right to be heard. Then we would concede to the wisdom of the court in allowing that the claims be admissible, and I'll proceed to submit on the merits. With respect to the first claim, Your Excellencies, the applicants have submitted before the court that the immigration policy of legacy is in violation of its international obligations, to which we submit to the contrary. From the onset, we wish to propose a test before this honorable court in terms of gauging and measuring the immigration policy. And for that, we draw inspiration from the jurisprudence of the International Court. And the reason why we draw inspiration from that is that the European Convention on Human Rights is a living instrument. Therefore, it must be interpreted in accordance with other international norms, even those that are not expressly provided in the Convention. Now, the International Court of Justice, in its advisory opinion over the unilateral declaration of Kosovo, underscored that conduct that is in conformity with international law is conduct where there is the absence of a violation of international obligations. And we submit that the immigration policy does not violate international obligations, rather it limits certain rights in terms of the law. And I'll proceed.
Counsel, may I ask you, we are all aware of certain aspects of marginal appreciation in this area, but I would like to ask you about the assessment of particular circumstances by legacy. Did you conduct assessment on how many children are without parents in detention? Have you considered the rising sea and unprecedented floodings and other particular circumstances in this context? And also, do you have any analysis regarding unlawful entrance in your country? Thank you.
Thank you for the question, Your Excellency. Indeed, Legacy is aware of the effects of rising sea level and climate change, as is stated on paragraph number 18 of the Statement of Facts. Legacy is also aware of the increase in the number of migrants attributed to several reasons. Some have been attributed to the unilateral sanctions, and some have been attributed to the war that is being driven by the rise of the revenges. However, Your Excellencies, perhaps before I proceed to make any justification on the immigration policy, I'd like to create and establish the context within which the immigration policy arises. A reference to paragraphs number 19 through to 21 of the facts shows that the basis of the policy is the Legacy First Immigration Act. Now, in what context was the Act promulgated? The Act was promulgated particularly after paragraph number 25 of the facts, where there had been an attack and 8,000 lives were lost. Now, in terms of paragraph 20, it is expressly stated that the object of the Act is to make Legacy secure for its residents, not just the citizens, but its residents. Therefore, these considerations are important in determining the immigration policy. Now, particularly with respect to the victims of the effects of climate change, there is a wide range of jurisprudence that is applicable before the court. However, the facts that we have narrow down the applicable cases. And for this, we implore this honorable court's attention to take into account the case by the Human Rights Committee, being the case of Tetiota versus New Zealand. Now, in that case, it was accepted that the effects of climate change may cause undue hardship to a certain extent that they impact on the right to life, which is contained in terms of Article 2 of the European Convention of Human Rights. However, it was also stated that Tetiota had failed to reach the requisite threshold. The requisite threshold being that there must be a risk, but that risk must be imminent. There is nothing on paragraph 30 of the Statement of Facts that suggests that the 900 asylum seekers that have been expelled from the respondent state face an imminent risk to their rights to life. And with respect to the non-refoulement...
Counsel, sorry that I interrupt. I have full understanding that after this terrorist attack, there is a strong state interest to restrict immigration. But what have those children who came because they were persecuted in their countries of origin, and they came to Legacy, what do have they to do with that? Why can you can you detain children for purely migration-related reasons if you also take into account the UN Convention on the Rights of the Child, which says that deprivation of liberty of children shall only be a measure of last resort? And finally, isn't that a collective expulsion that is absolutely prohibited under international law? How would you justify that?
Excellency, most indebted for your question. I'll proceed to respond in two parts. Indeed, it is quite regrettable, particularly the effects that the children have come to face. With the second prong of your question, Your Excellency, while it indeed is a mass expulsion on the surface, there is need to assess the relevant facts in totality. The applicant has submitted that the expulsion itself violates the principle of non-refoulement. Now, the European Court of Human Rights has had several instances where it assessed the application of this principle. And a good example is the case of Jama and others versus Italy. Now, in that case, there was requirement on a plethora of legal instruments. However, one of the key emphasis was placed on the United Nations High Commissioner for Refugees note of September 2000, which indeed stated that even in the absence of formal recognition of refugee status, asylum seekers are entitled to protection, and we do not dispute that fact. However, the basis for disputing that fact is that applicant has based its submission on the 1951 Refugee Convention. And in terms of the same convention, Article 32 does provide that expulsions may be permitted in pursuit of national security and public order. It is evident on paragraph 30 of the facts that some of these asylum seekers were now resorting to committing crimes, and some of them were now resorting to accessing legacy illegally.
Counsel, if I may interrupt, don't you think, because the paragraph 20 of the problem says that this policy has predominantly benefited white-collar skilled immigrations, specifically from the Bundai and Bureaupolis states. So don't you think it's discriminatory because it's helping or supporting a particular group of people, specifically from the economic higher income groups, as well as from particular states? So this is a bit discriminatory in our opinion. So what do you think about that?
Indeed, Your Excellency. Now, paragraph 21 of the Statement of Facts does provide that pursuant to the research by the applicant, it does seem that the policy favors those migrants from Bondi. This is the perception of the applicant that were given on paragraph 29. But the fact is given on paragraph 16 of the record. It says that the policy is non-discriminatory. Therefore, it boils down to an evidentiary issue, Your Excellency. Now, in the case of Velasquez Honduras versus Rodriguez, there were several pieces of evidence that were brought forward based on reports by various organizations. And the approach of the court was to accept the same with caution. So there is a need to assess the personal opinion of the applicant against the fact, which is in terms of paragraph 16, that there is no discrimination in terms of the policy. With respect to the surveillance, I note that my time is up, Your Excellency. May I kindly have a minute to wrap up, if it pleases the court?
Yes, let's add this. I need to clarify whether we include the 2 minutes that were given to the previous team. Have those been included already? They have not. Okay, so they can be added here. Thank you.
Most indebted, Your Excellency, for that. Now, legacy's surveillance and algorithmic processing is justifiable under international law, particularly in terms of Article 8, which the applicant has relied on. Article 8, subparagraph 2 does provide that the right to private life can be limited under certain circumstances, and the test is threefold. This was also confirmed by the European Court of Human Rights in the case of Zakharov versus Russia. The limitation must be in terms of the law, it must be in pursuit of a legitimate aim, and it must be necessary within a democratic society. With requirement to the first prong, indeed, the policy is in terms of the Legacy First Immigration Act, as appears on paragraphs 19 through to 21 of the facts. With respect to the second prong, the pursuit of a legitimate aim, again, the facts in paragraph 20 do provide that the rationale behind the policy are national security interests. With respect to the test for necessity, as was established in the case of Handicide versus United Kingdom, where a policy limits certain rights, it must be demonstrated that this is the least possible, the least intrusive measure possible. And we do submit before this honorable court that based on the national security interests which are at stake, this indeed is the least intrusive measure possible. Now,
Counsel, if I could ask, given the fact that there's some evidence that the use of these technologies have a funnel effect which are making people cross a more dangerous borders and taking greater risk to their life, isn't there a risk that this is not a proportional act, that is not necessary?
Thank you for your question, Your Excellency. May I have an additional 30 seconds to respond to the question? I see that my time is up.
Yes, please.
Thank you. Indeed, Your Excellency, the effect of the policy is regrettable. However, the policy finds itself within the context of trying to balance national security interests. If we are to draw inspiration from the jurisprudence of the African Commission on Human and People's Rights, particularly the case of Constitutional Rights Project versus Nigeria, it was stated that the limitation of a right must not be to the extent that the right itself becomes illusory. Now, the right remains, but there is a limitation. We do not suggest before the court that the system is flawless. It can benefit from certain recommendation from this honorable court, such as having independent oversight with respect to the surveillance and processing of data, as the European Court duly recommended in the policy surveillance measures. However, our submission is that the policy itself is not a violation. And unless if there are further questions,
please
I'll defer.
Try to round up your statement.
I'll now defer proceedings, Your Excellency. Most indebted.
Thank you very much. So the second oralist from the respondent state can take the floor.
May it please this honorable court. My name is Michelle Chiwanga, second counsel for the respondent. I will be making submissions on claims 3 and 4. With leave of the court, I will proceed to make submissions. With regards to the first claim, the applicant submitted that the respondent is in violation of the applicant submitted that the respondent is in violation of Articles 3, 8, and 14 of the European Convention on Human Rights. We will address these allegations as follows. Firstly, with a look at the allegation that there was in fact a violation of Article 3. However, we find it necessary and implore this court to draw its attention to the fact sheet, particularly at paragraph 25, wherein the gender identification policy was clearly enumerated as per the executive order to be the mandate that only 2 genders be recognized as at birth. This is necessary so that the issue of Ms. Cook's transgender treatment versus the policy itself are not conflated as one particular concern. Rather, the allegation on the applicant's part stands as follows, and I read verbatim what their claim is. It states that Legacy's policy on gender identification is inconsistent with its human rights obligations. What is in question is the policy and not Ms. Cook's treatment. It is in response to this that the applicant submits as follows. Firstly, the respondent submits that Legacy's binary-only policy aligns with its human rights obligations. This is premised off of the following prongs. Firstly, in the absence of an absolute right to self-identified gender recognition, Legacy's binary-only policy falls within the state's legitimate margin of appreciation. Pertaining to the margin of appreciation, the applicant argued that there is indeed a reduced margin of appreciation and cited the matter of Goodwin versus Cook as decided as Goodwin versus the United Kingdom as decided before the European Court, which is analogous to this particular court as per paragraph 10 of the fact sheet. However, this utilization of this particular case actually falls in our favor, and I will establish why as I go further into these submissions. With regards to the question of margin of appreciation, we fully recognize the polarizing nature of this principle, as it is often used to undermine existing international rights obligations. However, we submit that in this present matter, that is not the case at all. Instead, this is a principled exercise of this doctrine, reflecting its need to bridge the gap between flexibility with regards to state sovereignty whilst simultaneously upholding fundamental freedoms. It was defined in Handyside versus the United Kingdom, which was decided after the Goodwin judgment, that a legal principle recognizing that national authorities are better placed than international courts to assess their needs is indeed necessary. And it was further elucidated in Van Cook versus Germany, wherein at paragraph 69, it was stated that where we have a question and we have the absence of consensus among states as to the importance of an interest in question, as well as the manner in which that interest should be protected, the margin of appreciation may be utilized.
Counsel, please, I would like to actually draw your attention to one important requirement. It is true that wider margin of appreciation is granted when national laws do not stipulate gender identity, but there is also important obligation of high contracting parties, and that is to harmonize their legislation with international standards. Do you think that invoking old case law, and I admit that there is no much of a recent case law, but there are practices in different aspects, and notably the living instrument doctrine, which is applied more and more. Do you think that some of these requirements regarding wider margin of appreciation, if national laws do not stipulate gender identity issues, is dominant over requirement of a better harmonization of national laws with international standards, and notably with the case law of international courts and the treaty bodies of the United Nations? Thank you.
We completely agree with the position that there is emerging opinion juris on this particular matter. However, our submission does not contend the existence of a need for harmonization. However, we respond directly to the claim, which is that there is existing legislation that we are currently in contradiction of. We submit that there is, in fact, no binding consensus, and our submissions follow closely the case law of the European Court on Human Rights. The applicant cited the matter of Christine Goodwin versus the United Kingdom as its primary basis upon which they to state that self-identified gender recognition should be legally recognized. However, even in the matter itself, the use of the Goodwin case is reductionist. The reason being, in the Goodwin case, the applicant in question had gone through gender reaffirming surgery, and the questions that were considered are not directly applicable to this matter. But in this instance, even if it were that that judgment is used to affirm this position, we further submit that our position is not that there are no judgments that lean towards the applicant's supposition. Our submission is that there are diverse opinions and perspectives elucidated by the European Court as to how to handle this matter. The Goodwin judgment was established in 2002, and subsequent to that, we have had multiple judgments that stand in contravention of that. We draw the court's attention firstly to the matter of Perry versus the United Kingdom, when pursuant to the applicant's gender-affirming surgery, the state refused to alter the documentation to reflect this official change in gender. However, despite that, the court, the European court that is, upheld that judgment on the basis that the state enjoyed a margin of appreciation on the matter on the basis of an absence of a binding legal international consensus. I further
Counsel,
acknowledge Your Excellencies.
If I may interrupt you, sorry. I fully understand your your legal arguments, but if you look at paragraph 26 of the facts, the fact that the president issued an order that there are only two sexes, male and female, as assigned at birth, have led to the fact that a transgender woman was forced to be detained in a male detention center where she was humiliated, threatened, etc. Is that not a violation of Article 3 of the European Convention? Is it degrading or inhuman treatment, in your opinion?
With respect to Ms. Cook, we fully recognize that in the instance, the occurrences that happened to Ms. Cook are not acceptable at international level. We recognize again and draw the court's attention to the very nature of the claim itself. It is regrettable that Ms. Cook underwent such treatment, but the policy in question, we reiterate, concerns the legality of that particular provision, whether or not the policy itself and not Ms. Cook's treatment is consistent with international human rights obligations. We proffer as follows pertaining to the aspect of Article 3 that Your Excellency so eloquently raised, again in response to what was stated by the applicant state. Firstly, the applicant alleged that there was a violation. However, they failed to meet the applicable threshold, or they did not establish the evidentiary threshold they have to meet to satisfy a violation under Article 3. Particularly, the applicant is tasked to demonstrate that the binary policy itself conditions and exposes all detainees to these specific vulnerabilities. We emphasize the aspect of all detainees because the perspective that looks and focuses solely on Ms. Cook's treatment fails to acknowledge what the policy in essence actually is. And the policy is a policy of blanket application, not one that is stated and directed only at transgender individuals. It is on this basis that we further submit that in the absence of a concrete and substantiated burden of evidence from the applicant, that the policy creates a real and imminent risk of inhuman and degrading treatment upon all potential detainees. Article 3 in this case is not engaged. Particularly, as was stated...
Counsel, apologies for interrupting you. I'm just wondering, are we not splitting hairs here? I hear the argument which you're trying to say. The claim is focusing on the legality of the policy, or it's consistent with human rights, not necessarily its impact on Ms. Cook. My question here is: are we not splitting hairs here? Of course, the legality or the impact of this, or what Ms. Cook faces, is a result of this particular legislation.
The applicant, the respondent, fully recognizes this position. However, it is necessary to draw the court's attention to the fact that this policy's applicability to other detainees is relevant as well. The framing of the claim itself becomes relevant because the consistency or inconsistency of the policy with international obligations arises from its impact on all the individuals that are subjected to said policy. Looking specifically at transgender individuals then limits the scope of the policy. We recognize, as the respondent state, that there is absolutely room for reformation of that policy with regards to the treatment on transgender individuals. However, we refute the claim that the policy in itself is inconsistent with any existing human rights obligations. I recognize further, as was stated earlier by Her Excellency, that there exists a rising international standard, such as the Yogyakarta principles that advocate a more diverse perspective when it comes to gender identification. However, we still reiterate the position that this existence of non-binding law does not reflect an existing international consensus, further substantiating the position that there is no existing international human rights obligation that could have been violated. Furthermore, the applicant cited a very impassioned plea concerning how a woman is defined within the 21st century. However, we draw the court's attention to the fact that that is not an existing legal standard. In fact, the interpretation of a woman is something that is a broad question under international law, with certain bodies, particularly bodies concerned with the interpretation of the Convention on the Elimination of Discrimination of all against women, that it particularly states that this definition being inclusive of non-binary individuals is a matter of question. It is on this basis that it cannot be utilized as a binding argument against the respondent state in this particular instance. If the court is satisfied, the applicant would like to move, the respondent, I beg your pardon, would like to move on to the fourth claim. Much obliged, Your Excellency. The respondent state, with respect to the fourth claim, submits as follows. The applicant state alleged that Legacy's unilateral imposition of sanctions on Chitauri and Roa stands in contravention of international obligations. We draw the court's attention first to a question that was proffered to the first oralist for the applicant with regards to the jurisdiction of this court. We draw this attention because there is an intersectionality between this claim and the question of jurisdiction. We submit as follows. Firstly, the applicant argues that the scope of this court's jurisdiction...
Counsel, sorry to take you a little bit back. I hear your argument that you're saying, well, there is no existing law that perhaps can function against the position of the respondent in this regard. I'm just wondering, can this court, towards the development of human rights norms, because human rights law, as you'd agree, Counsel, is all about protecting human beings, protecting individuals regardless of politics that may be existing. Can this court move towards perhaps trying to guide the world towards, recognition beyond non-binary in this regard? What would be your argument against this court recognizing or trying to be bold and take a step towards that?
We recognize the need for this court to be progressive, to echo the sentiments of the Charter and make sure that it moves in accordance to the need of evolving society. However, we also draw the court's attention to the very important norm that is state sovereignty. In this instance, let me explain what the intersectionality is. The utilization of this policy was not in any way arbitrary, but came from a rising need that is a direct response to national security risks that have been heightened over the past few decades within this particular region. We draw the court's attention furthermore to the fact sheet itself to show the fact that this policy was in fact in pursuit of a legitimate aim, and it was done in a manner that reflected proportionality. We draw the court's attention to the following compounding factors that necessitated the utilization of this policy. Reference to paragraph 18 also shows the facts that it shows that there was a surge in migrants arriving from Chitauri to the Republic of Armada to Legacy. Furthermore, paragraph 25 then mournfully narrates the mass murder of 8,000 civilians within Legacy, as well as thousands of injuries, again, reflecting this heightened risk. Lastly, this coupled with the revenge as child conscription and abduction as shown in paragraph 12 shows that these heightened security risks are real and not something that was invented by the respondent in pursuit of violating human rights obligations. It is because of this that we submit that this policy was taken in an effort to preserve our public order and national security, which is integral. So much as the court has the leeway to move in a manner that shows sympathy towards particular communities, there's still a need to balance national security interests as well as the interests of particular marginalized groups. If it satisfies Your Excellency, I will go back to the submissions on Claim 4. We further submit that with respect to Claim 4, Claim 4 that when it comes to the issue of sanctions, that where the applicant argued the violation or the deprivation of fundamental rights, that there is an obligation at international law that they prove that the respondent state was the sole or direct causation of these factors that led to the deprivation of fundamental rights. We submit as follows, that the applicant failed to adequately establish a nexus between Legacy's actions and the subsequent humanitarian crisis that occurred in the sanctioned states. We submit with
Counsel,
reference...
may I interrupt you there? I mean, in international jurisprudence, the extraterritorial obligations of states have been very well established. And if Legacy imposes sanctions on another state that have direct consequences on the enjoyment of human rights, is there not such an extraterritorial obligation of Legacy?
Your Excellency, we recognize in the instance where it were the factual position that the respondent state's actions contributed to this loss of rights, that there would be responsibility that would accrue as a result of that. However, we contend the position that the responsibility lies at our door, and this can be proven by reference to the fact sheet itself. Particularly, we submit that there are multiple intertwined causes beyond the sanctions that actually resulted in this deprivation of rights, and attributing it solely to the respondent is blaming in a manner that is erroneous. We draw the court's attention to paragraphs 14 and 18 that show the climate change implications upon these particular continents. We further draw the court's attention to paragraph 14, which shows internal displacement and regional instability, which again strained social support measures as well as the economic systems of these nations. Furthermore, we have paragraph 3 and 14, which reflect pre-existing vulnerability in these states, which were based off of their extraction-based inequalities. All of these factors compounded further affirm the fact that there are other existing factors that may be argued to be of greater impact than the singular sanctions brought forth by the applicant state, by the respondent state, I beg your pardon.
Counsel, if I could interrupt briefly. Article 2.1 of the International Covenant on Economic, Social, Cultural Rights talks about, has an obligation of cooperation, international cooperation. Given that there are other factors that are involved, as you've just raised, in the economic situation of these countries, we do know that the sanctions have led to devastating impacts on healthcare, food, education, and employment. How can these be justified under the Legacy's obligation to cooperate internationally in relation to economic, social, cultural rights?
And just one follow-up question in respect of what you've just said before Mr. Walker asked you the question. You mentioned several reasons and vulnerabilities, but do you mention them in order to justify preemptive action in terms of protect your territory, or you would like to address specifically this preemptive protection? Thank you.
Much obliged, Your Excellency. We submit as follows, that the utilization of the sanctions in themselves, that non-forcible sanctions are not inherently illegal. This was echoed in the case of Nicaragua versus United States, when it was stated that the trade embargo utilized by the United States against Nicaragua did not attribute responsibilities for subsequent loss of fundamental human rights within that particular state. And in that instance, the United States even had military forces within that state. However, before I digress, I withdraw the court's attention to the claim sheet as per paragraph 9, wherein we see that Legacy and other Bureaupolis states mobilized resources to assist Bundai in defending itself against these assaults. It shows that there is this obligation of cooperation, as stated by His Excellency, is in fact satisfied by the actions of the respondent state. However, with regards to the question of whether or not we are utilizing the existence of other concurrent factors as our justification for the sanctions, we submit that we are not. Your Excellency, I note that I'm out of time. May I plead the indulgence of the court to respond to Her Excellency's question?
You have 1 more minute. It will be added to the time of the applicant team for his rebuttal.
Your Excellency, summarily we submit that the utilization of sanctions is not inherently inconsistent with international law provisions. We further submit that our utilization was in fact a proportionate and necessary measure to protect the national security of our nation in the face of heightened security risks. This is again echoed in the Gapsikovo-Nagamara's case before the International Court of Justice, where it was made clear that measures utilized should be directly proportionate to the harm that is being faced. We submit with reference again to the paragraphs concerning the heightened security risks, as well as what happened to Bundai pursuant to continued trade relations, and submit that it was in fact necessary for us to utilize these sanctions. We then submit that in terms of our prayer, that it be received as was proffered in our written submissions, and draw the court's attention to Articles 1 and 2 of the Articles on State Responsibilities for Internationally Wrongful Acts, when it is made clear that responsibility only accrues where there is a violation. We maintain that there were no such violations. Thank you for your time, Your Excellencies. I happily yield the floor back to the court.
Thank you to the respondent state. Now is time for the applicant for his rebuttal. Entonces, la parte demandante.
So, the applicant, you have time for your rebuttal within the speaking time. 6 minutes to reply.
Honorables jueces.
Using our right to rebuttal, we would like to mention everything that has to do with admissibility, jurisdiction, and questions on the merits. We will be talking about ratione materia, first of all, establishing the fact that a court can be apprised of the consequences in human rights when we're talking about these actions. However, they are wrong when they say that we haven't proven this relationship between the actions and human rights. We clearly established, as per Article 8, it includes the right to health, right to moral, physical integrity, and well-being. Despite this, they weren't able to answer their allegations, particularly regarding the health issues and food. As per Article 27, they talk about the lack of exhaustion of domestic remedies, saying that they were just extraordinary measures. This is something which is a false statement, according to 32 Cook, and deliberately they ignored the arguments regarding the lack of availability of these remedies, and they didn't provide a sufficient answer on that. On question 1, a flagrant lie here. This law came after the terrorist attack in Legacy. That's false. No, this is 2025. You see that this was something that happened earlier on. There was a question regarding discriminatory questions, something that violations the principle of non-refoulement. They keep going back to 16, and this describes the legal situation of Legacy prior to the passing of the Legacy First. If you want to know the current situation, you should go back to 29. In fact, 29 says exactly how they are rejecting Afro-Polynesians' requests simply because of their nation. This is racist. It is racist. It has nothing to do with Articles 13 or 14 of the European Convention. They haven't been able to address that. On to It's a shame that the state agency didn't talk about the legality of the law, nor did they develop anything on safeguards, which they are obligated to under Article 8. A shame that they failed to develop arguments on how technology can reproduce inequalities. They have deliberately ignored that point. On question 3, they also are overlooking the developing nature. There is one case against the United Kingdom, which is something which is a case in point. And the use of this precedent, this had to do with a woman who hadn't undertaken surgery. If we go back to the precedent, SB versus Italy, where a transgender individual wants to be recognized without having gone through gender reassignment, and the paragraph in the respective courts condemns the Italian state for demanding that surgery, which is incompatible with a state upholding human rights. Under 4, they blame Hyundai wins 56% of the Chitori economy depends precisely on the import of food and tourism. They attack that, knowing that this would affect individuals. In addition, they overlook the question of reparation. They didn't even mention reparations. So, first of all, you need to ignore the initial argument. Secondly, responsibility. And thirdly, that they make a stance and declare their arguments on reparations. Thank you to the applicant.
The allegations of the parties. The court will adjourn in order to consider and assess the arguments. Thank you.
Veronica Gomez presiding.
Good morning, ladies and gentlemen. Can you please take your seats?
Okay, well, we're back after our deliberation and where the computations are made. We have very short minutes to give feedback on the exercise. Now from a perspective of, from a pedagogical perspective and from the point of view of the experience and what it means to participate in a moot court. So the judges are going to do this individually. So first I'm going to give the floor to Judge Naim.
Thank you so much. And again, good morning, everyone. And congratulations to both the teams for doing all the great work and amazing presentations today. Overall, we can see that both the teams have done really good job. And we can clearly see that you have put a lot of hard work in your preparations and you know your case, you know your case laws and everything. So I would just give some general comments. So of course, the first thing always is the time factor, and judges are asking questions. It's their job to ask questions. However, always try to answer precisely. And if you move to the next question, I would say that you ask the judges if they are satisfied with your responses, because I understand because of the time pressure, you would like to finish your arguments. But these are general comments and observation for both the teams. So first one is on the time factor. Second one is on the case laws. I would say strengthen your command on the case laws. You are lawyers in front of a court. So try to give more precise and accurate reasoning, which were produced by the court, and link it with your arguments. That's the second one. The another one is on the facts. Sometimes try to link with the correct paragraphs, or whenever you are going to give the argument, or linking with the case laws. So that's another argument. The third one is also try to, because it's an international human rights law, try to also give not only just the judicial cases, but also, like we saw that in this case, all the states are parties to different committees, with all the human rights treaties. So try to give reasonings and linkages and jurisprudence from different treaty bodies and other regional mechanisms, etc. So try to make it more holistic approach while you are arguing these cases, because it's not just about the jurisdiction thing, but also that if you are party to international human rights treaties, you also have international obligations to implement those human rights obligations to which you are a party to a treaty, etc. So I would stop here, but otherwise, congratulations to both the teams. You have done a great job, and all the best with the result.
Thank you very much. Now, Mr. Samuel Walker.
Thank you very much, and good afternoon, everyone, and congratulations to both teams. I think you've done a fantastic job, really impressive. The level of I think capacity, capability, and knowledge was very high and very close between both teams. So you've done an impressive job. I would echo what was just said actually about the international jurisprudence, particularly the views of the committees that have individual communication procedures in the UN system, but also the general comments, which some of which are in fact often relied on or are relied on by regional courts, but also national courts as well. So, but of course, you have a limited time and it's not easy to cover everything in that space. I was really impressed by your knowledge of the law and also by both sides by your coverage of the various issues that you had to present under the different areas where you were you had to make presentations. I think the delivery was really good. I think the first speaker for the applicant was extremely energetic. Maybe be careful, particularly with your response where it was possibly energetic, going slightly aggressive, talking to about the other team. So just maybe be careful with that aspect, and also with just with the second speaker for the respondent. I think you had an extremely measured, moderated, calm presentation, which was, I think both were excellent. I think you were all excellent, but I think it was also, I really enjoyed listening to you on that. So, and yes, so I'll leave it there. Thank you. Well done.
Thank you very much. Professor Chinget.
Thank you very much, Judge President. And let me also express my real appreciation to the teams for the hard work that you really put into participation. And I really acknowledge this sincerely. I know all this fantastic work that you were doing, it's something that you do as extracurricular activities from your busy studies. And coming out here and giving this kind of high level presentation is something that I have to comment on both sides. I would say this actually, and I meet many teams sometimes, but I have to say this, that if I was the victim of the human rights violations that were being alleged in this case, I wouldn't mind being represented by you as my lawyers, as the applicant. If I was, a politician belonging to the government, I would actually also not worry being represented by you as actually really fully qualified lawyers, because it was that excellent. I've seen, many otherwise perhaps qualified lawyers who argue in court, not at the level that you actually were showing, where most of you are not reading. It's coming from your head and articulating these issues under so much pressure. Well done for that. I can only say the future is really, really bright for all of you, and well done on that. In terms of specificity, if I'm on the question of the side of the applicant, I really appreciated that you adopted the stance of what an applicant has to do, complain a lot, like show actually why there is a problem. I think you did a fantastic job. I would only perhaps just with a fellow justice question on the question to say also have a balance, so that there is a slight difference when now in a court of law and when you are outside just making for example an activist approach. But otherwise, I like the passion and the dedication. In terms of the law and facts, still on the applicant, again a very, very adequate job done. But I would also recommend in the future, just also try to make sure you identify key cases that you want to use, and you are more specific on paragraphs that you're relying on and how they're applying to the facts. What was the reasoning in that particular court? Was it just a sentence, a quotation that you're getting from, was it obiter? Was it the reasons for the decision? Like, it has to be clear actually. And I know you are under pressure, but try then perhaps to limit a little bit of maybe the number of issues that you are engaging with. Answering questions, I would also emphasize that that's one of the important, also one criteria that we use to judge. So please, when a question is asked, as one of my fellow judges was saying, try to perhaps check in if that particular question has been answered. Of course, you are trying to rush to the next point, but it's an important aspect. On the side of, again, the respondent advocacy, I said, again, I think you really also adopted a very good stance of what a respondent would do, especially representing a state. Number one, I particularly liked the aspect that you were not in a way coming across as if you are advocating for violation of human rights, but trying to find exceptions why in this particular case it shouldn't go against you. And I think that was really well done. Law to facts. I must really comment, at least, and not to just try to single one person. Your reference and knowledge of law, I think it was the first speaker of the respondent. I think that was really excellent. It appeared to each question that was being asked, you had a case and a particular provision that you had to support. So your knowledge of international law there is really recommendable. And answering questions also very good. And that's why I would want to end and simply say, it was really a pleasure listening to both of you. I can only say really well done.
Thank you. Judge Jelly.
Thank you, Judge President. I would like to congratulate to both teams and to all four speakers. I'm impressed with your knowledge of international law. And I was also very happy to witness that the case law standards set forth by the European Court of Human Rights are understood correctly and applied in a pertinent manner when it was possible. So for me, all four are excellent, and this is what I wrote. There are nuances, and now I'm going to, in general, say several things that I hope would be helpful to you in your future work or another Moot Court competition. So I'm aware that it's not easy to manage time. It's a limited time, and you invested a lot in preparation. Your knowledge is much bigger than the time limit. And it's also very difficult to manage, on the one side, to say everything you prepared and planned, and then to answer to our questions that sometimes can take you away from your direction. We do it sometimes intentionally, and that's normal. We do it in a good faith. So in bona fides, in order to, and in a good faith, to actually help you, to help us to decide on those nuances. And also to show how you manage with unplanned situation, because knowledge is not only to say everything you prepared, but also to find out the way based on your knowledge and good preparation to find a way in difficult situations, in challenges. And international law is full of challenges, especially nowadays. So one small suggestion, which makes difference in general, is that when you get a question, you give full attention to it. You don't say, oh yes, I agree, and then you continue with what you have prepared. I think instead of that, which I heard at least twice today, I think you should try to give arguments and go a little bit out of what you prepared, because you invested a lot of time and you have much more knowledge, we are aware of that, than you present. So try to give arguments and then to connect with what you wanted already to say, with what is actually the next sequence that you had planned. So that would be my suggestion, because this is where I saw difference among four of you. Thank you.
Thank you very much. Professor Novak.
Yeah, thank you. I agree with my fellow judges. You were all excellent, and that's what we expected, because that's why you are the finalists in this Moot Court. Not only in terms of preparation, of course, but also the general knowledge of international human rights law, but also going beyond international law in general. If I may just say a few words on the, how I experienced the four different speakers. I think, Mr. Rincon, you were very well prepared and structured in your first statements, but you were probably more often interrupted than other speakers, and you reacted very, very well and in a very knowledgeable way to the questions, although it was almost impossible to really respond to all the questions in the limited period of time. In the rebuttal, I felt that you became a little too agitated and was very, very quick also for the interpreters to actually follow and interpret. Mr. Joe, I felt you were sovereign. You were very excellent and very articulate in the way how you presented your arguments, but also in the way how you responded to the various questions posed to you as well. For the respondents, Mr. Sumarai, I think again, I was very impressed by the way how you started the whole presentation, and also the arguments that you put forward in relation to jurisdiction, exhaustion of domestic remedies, etc. When then more questions were asked, again, very, very good responses. There were little mistakes also partly on the facts. And for Ms. Chiwanga, you were again very well prepared, self-assured. I felt in responding to questions, I had sometimes the feeling that you evaded a little bit the answer to the questions that were posed to you. But as I said at the beginning, I mean, all four of you are extremely well articulated and knowledgeable individuals. So I wish you all the best also for your future career as practicing lawyers or judges or whatever you would go to do.
Thank you. Well, I think this is very good feedback from the judges. Only to add that again, congratulations for reaching the final. Obviously, the teams both are very good. Through this process, you've fulfilled different roles to get to here. It was very interesting to see your deliveries. They were very good. They were really, really excellent. In the case of the applicant, the deliveries, they all had different styles. The four of you had different styles. In the case of the applicants, sometimes it was maybe a little bit too strong for a court of law, but very clear. It was very clear, very distinctive, very, very well organized. Careful with the movement of the body. Maybe that was also, sometimes it might help to emphasize certain phrases, but it can also be very distracting, doing this, Sometimes it distracts the person who's trying to listen to you. But it was very clear and very, very well done. It was also clear how the respondent acknowledged certain issues that maybe were not, the acknowledgements were not necessarily in line with the interest of the state. Careful with that, because in international law it has a meaning. All those acknowledgements have a consequence. It might make you feel better because maybe in the bottom of your heart you sympathize with the position of the applicant. But in an international court, all those acknowledgements, you pay for them, in the reasoning, in the reparations, etc. So you have to be very careful with is how you go through that line, how you walk that line between not sounding unreasonable when faced with a human tragedy, not sounding unreasonable, which is a very important thing to do, a very important strategy of the state, but at the same time not cross the line and make an acknowledgement that will cost you, in terms of responsibility. Well, those are, I think I'll leave it there. And then we can move to the most important part of this final round. So I pass the floor to the organizers.
Thank you very much to the judges for those remarks. Just to introduce myself, my name is Frans Viljoen, and I'll speak on behalf of the Center for Human Rights at the University of Pretoria as the co-organizers of this event. And I thought it may be good for us just for a moment to think about the time and the place in which we find ourselves. As we know, this Nelson Mandela World Human Rights Moot Court competition is always held in the week when we celebrate the birthday of the great Madiba. But today is exceptional because it is actually the day, as we know. The 18th of July is the day when we remember his birth, and the world celebrates the life and works and the influence that the great Nelson Mandela had, I'm sure, on all of us. So that, I think, makes today very, very special. But in a sense, we also live in a time that for different reasons is special in a negative sense. I mean, we all know about the anti-rights agendas. We know about the skepticism and the cynicism that there is towards and about human rights, in particular international human rights. So I think perhaps today is a day that we can all be inviting ourselves and challenging ourselves to think, what is it that we draw from our togetherness here? How can we take strength in having perhaps forged new bonds with others who are similarly situated and believe and think about things in ways that are similar to how we see them? And perhaps how can we continue to draw on the life of Nelson Mandela and to see him as this symbol of global human rights solidarity? How in his life also he never stopped to be committed to human rights, but also emphasized the role of the international dimension of human rights and its role in the liberation struggle in South Africa and in its own role. So let us draw strength from our own collective experience and our memory of the great Nelson Mandela, in whose name we are together, in a sense, today. But I also think we can draw and think about the place in which we find ourselves. As you know, this is room 20. This is the room where not many days ago, the Human Rights Council of the United Nations actually met. So this is the nerve center, as it were, of human rights. And it's wonderful that we are also here today in this room to reflect on human rights. But I mentioned this room also to bring into play one of the partners that co-organize and are jointly together working on this mood together with us, which is the UN Human Rights Council branch of the Office of the High Commissioner for Human Rights. And I just want to acknowledge their support, in particular, Ms. Mariana Oliveira West, the director of the UN Human Rights Council branch, and also those who are more on the ground working with us. We have Pascal Sim, David Martin, and Matthew Brown, who are all working with the media and publication and information part of the United Nations. We really appreciate your contributions, not only today, but over a long period of time. You know, as soon as we end now, then in a sense, the next year's planning gets underway. So thank you so much to our partners here at the office here inside the UN. Now, I think we also have to count the years. We say it's the 17th Nelson Mandela Human Rights Moot Court competition. This would only have been possible not only with the UN as a partner, but also other partners. And today we just acknowledge also our partner, the Academy on Human Rights and Humanitarian Law at Washington College at American University in the US, who are consistently supporting us, and also the Commonwealth Secretariat, also represented here today. We also have the partners, the financial partners, the donors, if you like. And here we acknowledge the European Union support for the Moot Court this year and previous years. They do support the Moot through the Global Campus of Human Rights. Now, as I think you may have heard, the Global Campus of Human Rights is a network of master's programs across the globe, which are all supported by the European Union. And it brings together a total of around 100 universities and through these 8 programs. We were privileged that the Secretary General, Professor Novak, and its President, Judge Gomez, are represented here. But it's only a token, really, of also the much deeper support that the Global Campus has given to this Nelson Mandela Moot Court competition, because it fits so well with the ambition and the mission of the Global Campus. We also acknowledge the support of the Swiss government over many years, but also this year in particular, that made it possible for us to work on logistics around the Moot. But those that need to be mostly thanked and congratulated are you, the participating students, participating universities. I think that I first want to emphasize the role of the lecturers, especially those who are here to here. You are in a sense, you are the kind of lifeblood of the competition, because you continue sustaining it through your support. And for those who are here and had the experience this year, we really commend and congratulate you and wish you all the best, and hope that this was an inspirational and transformative experience here together with us. I can just say that also for the judges, to remind you that the Moot is really a protracted process. It starts with memorials, which are presented. More than 80 teams presented memorials this year. Then from the 80, we come to 50 on the basis of the marking of the memorials. Those 50 teams then participate in rounds that are online. And from the online participation, we get to the 24 that come to Geneva, and then there are rounds that lead to the quarterfinals, semifinals, and eventually we only see today the culmination of all those processes. To say that in the 50 best memorials, I just want to highlight that the teams there came from all the regions of the world. And in the 5 UN regions, I want to single out the countries from which we received most of the best memorials. The countries are in Asia, India; in Africa, Nigeria; in Latin America and the Caribbean, Brazil; in the West European and others, it was the United Kingdom; and in Eastern Europe, it's Hungary. So we also take note of those. As far as the top 24 teams are concerned, we had 8 teams from Asia and 5 teams each from Africa, Latin America, and the West European and other, and 1 team from Eastern European region. So, as is our custom, we will then also now just give the names of the top 10 teams in the preliminary round. So those are the rounds that were the virtual rounds. So at least we also acknowledge, because that's the basis for the teams to proceed. And we just briefly read this out. Although there is no specific prize, I think it is just an acknowledgement, and the full list will be placed on our website soon, on the Moot Court website soon. So in the 10th place in the preliminary rounds, and that's for both languages, all the languages, may I say that in general, the languages in the Moot Court competition are English, French, and Portuguese, English, French, and Spanish. But this year there was no French participation that made it possible for them to be a team that had participated in the virtual rounds. So in the 10th place of these preliminary rounds was Universidade de Sao Paulo in Brazil. In the 9th place of these preliminary rounds was University of Santo Tomas in the Philippines. Number 8 was Midland State University in Zimbabwe. Number 7 was Strathmore University in Kenya. Number 6 was Kenyatta University in Kenya. Number 5 was Symbiosis University or Law School in India. 4, Kabarak University in Kenya. Number 3, Universidad de San Carlos de Guatemala. Number 3 was NALSAR, that's the National Academy of Legal Studies and Research, University of Law in Hyderabad in India. And then in the first place was Universidad Nacional de Colombia in the preliminary round. So congratulations to those teams. So we also move to the individual best performances in those rounds. So to emphasize, these are for the individual rounds during the online competition that was, as you know, very intensive. We will mention the top 5 oralists, and then there is a prize, and we'll ask the best oralists in the Spanish rounds to come forward. So in the 5th place, in the preliminary rounds for Spanish language participation was from the Granada University Spanish team, Garzon Hassan. In the 4th place was Universidad de San Carlos de Guatemala, was Luis Roman. In the 3rd place was Universidad San Carlos de Guatemala, Carla Castillo. 2nd runner-up was from Universidad Nacional de Colombia, John Santiago Cifuentes Ricon. And the best oralist in the Spanish rounds, also from the same university, is Emily Pedraza Ochoa. And I ask you, we ask Professor Manfred Novak to please come to the front and hand to the winner. We ask the winner, best oralist, to come to the front in the Spanish rounds, and Professor Novak will hand to you this plaque that you can take home and put on your wall. Thank you very much. Congratulations. So for the English-speaking universities, during those preliminary rounds, we announced the top 10. And
the interpreters apologise, but we've given nearly an extra 20 minutes and now have to stop interpreting. Thank you for your understanding.
Was from Strathmore University, Ochieng Jane Rose. The 9th was Dar Archisa from the Symbiosis Law School. The 8th was Torotich Joladi from Kenyatta University. The 7th was Watson Tonderai Somerai from Midland State University. The 6th was Bat Shashank from Symbiosis University. Number 5, Joel Cruz from University of San Tomas in the Philippines. Number 4 was Esther Bising Nasimiu, and that is from Kabarak University. Number 3 was Prasheta from Nalsar University, Hyderabad. Number 2, William Foxton, University of Oxford. And the best oralist in the preliminary rounds was from Nalsar University, Hyderabad, Deepan Shka. So we wonder if she's here. Deepanksha, congratulations, and we ask Yash Naik to please come to the front from the Commonwealth Secretariat to hand the Best Oralist Prize for the individual rounds to Deepanksha. Thank you very much. Thank you very much. There is also an award for the best memorials. As you know, that the memorials are very pivotal in the initial phase, but they become less pronounced in the final phases. But we do also acknowledge the best memorials in those preliminary rounds, in the preliminary phase of the competition. We believe that maybe the memorial winners are not here, but let us make sure. In the 3rd place for the Spanish was Universidad Católica Boliviana San Pablo, that is in Bolivia. In the 3rd place for the Spanish memorials, Universidad Nacional de Colombia, and the best memorials came from the Granada University, the Spanish-speaking team. However, they are regrettably not here because they could not make it to the final rounds of 24. In the English-speaking memorials, we have in the 5th place for the best memorial, Strathmore University, Kenya. Number 4 was Jindal Global Law School in India. Third, the National University of Study and Research in Law in Ranchi, India. The second best memorials goes to London College of Legal Studies, that's in the United Kingdom, and then the best memorials were submitted by Idiatullah National University in India, but they are also not here. They actually did not make it to the last 24 universities, but nonetheless, they had the best memorials in the initial phase. So we will ship those plaques to those winning teams. So thank you, and we acknowledge their accomplishments in their absence. So to move on and just do a few thank yous, I'm sure we are now just doing some, introducing some suspense so that we get to the final moment. But I think it's not uncalled for to just thank a few entities or people. And the first I think need to be thanked would be the judges, the 6 judges who are sitting there. I think they are really the jewel in the crown of this moot. They gave such a wonderful engagement with the students. They add so much luster by being here and by presenting themselves in the way that they did. And I think you'll all agree that we were privileged to have 2 judges from 2 regional courts here and the other experts who brought their insights. So thank you so much for joining us here today, and we really appreciate you and your participation in this moot. But the judges in the other rounds need also be acknowledged. You can imagine you participated, you know that judges were there from the time when the memorials had to be marked, from those hours and hours of listening to online presentations in different parts of the world, in small and large hours of the day and night. And, you know, that really was only possible of the commitment of judges who are here, some, and others who are not here, but we certainly need to acknowledge their contribution. And today we have a special moment because there are 2 people present here who also participated here and had in the past been really stalwarts in the judging of the Nelson Mandela World Moot Court competition. And we have someone special here today, and we'll call her to just hand out plaques of recognition to these 2 people. So let me first introduce the person who will come to hand the plaques, and that is Fiarika Heinz. Now, Fiarika is the wife of Christoph Heinz, who is the person also who has been instrumental in thinking of and starting off to taking the initiative for this moot. We, in the center, if we think of who is the founding father of the moot court competition, then the answer is it is Christoph Heinz. So he is someone who has been here many, many times in the moot. He unfortunately passed away a few years ago, but we have Fiarika here who gracefully agreed to be with us today, and we're so happy that she's able to join and just also feed off this memory of what Christoph established through his life and works. And we ask you, Fiarika, to come forward to hand the plaques to 2 people that have supported the World Moot over many, many years. And the first is Armand Tano. Armand, please, if you can come to the front. I can just say that Armand has been there. The Moot has now been there for 17 years. He's been there for 17 years. He's now a practitioner in France. He always comes here basically pro bono, just sacrificing his time. This is the spirit of the Moot epitomized by Armand. Thank you so much, Armand. We never take you for granted. We're happy to see you back. And then we also do the same in respect of Baruana Calado, who is from Brazil. Yes. She may not have been there for 17 years, but since she joined the team, she's been the most supported, committed, dedicated team member who has come both to the Moot in South Africa and to the World Moot here. We really appreciate you very much, Baruana, and acknowledge your contributions. And we're happy that we could surprise you on this. So thank you so much, Verika, also for handing those out. Then I just also, during the week, we had the Nelson Mandela lecture, just to acknowledge also the contributions of many to that. We had a very fantastic lecture around issues of the work of the independent expert on sexual orientation and gender identity, Graham Reed. We thank him and everyone involved, including Cheryl Kunaka and others. And we just want to acknowledge the involvement of yourselves and those who contributed to making the Nelson Mandela lecture once again also a success. I come to the center team. Well, just to say, if I talked about, you know, the lifeblood, I think the center team is really the backbone and maybe the nervous system of this Moot. It has to work only because there are people making it work. I really want to, on behalf of the center, thank Lloyd Kuvaya here, who is the assistant director, who keeps his eye and his energy directed to the Moot throughout the year. We have all of the center team working on the Moot always, but here present we have Carol, Emily, we have Davina, and we have Sam, who are the ones who also just give selflessly, remain committed and dedicated to the Moot, and often in very late hours and unpredictable places find themselves keeping the Moot alive. So thank you very much to the center team. I also acknowledge Eduardo Capapello, who was a previous Moot coordinator, who was also, it's difficult to divorce yourself from the Moot, who finds himself here supporting us continuously over the years. But with anything like this, there's one person who wakes up in the morning and thinks about the Moot more than any one of us, and whose responsibility obviously is really burdened by this Moot and making sure that it is a success. And in this case, it is Tapiwa Muhuru here, and I'm sure all of you know him very well. And I think, Tapiwa, the applause says it all. We really acknowledge, appreciate you. We know that it's a long road. It's a difficult process to sustain. It's long and it's arduous, but it's been a great success. And we thank you for your commitment and hard work in making this the Moot that it is. So I suppose the suspense leads to the denouement, which is now where all the strands of the Moot comes together. And that must be in the final results. We ask that the auditors present results to the president. After the president has announced it, we ask, I mean, both teams will have a runner-up team and we'll have a winner team, but we ask Judge Jedic to then hand the prizes and the plaques to the runner-up team, and then the president will hand the plaques to the winning team. So auditors, are you in the room? You can present the results. Thank you very much. And a word of thanks to the auditors. Through my long list, I have not thanked the auditor. Thank you very much for your contributions as well, while we want to extend the suspense. Thank you very much.
So the first is the runner-up. So the runner-up is the respondent, the Midland State University of Zimbabwe. No. I asked, was it the runner-up? No? Ah. This is like the Oscars in it happened. I asked if it was the runner-up, and they said yes, but actually they gave me the winner. They gave me the winner. This is the winner. So the winner is, excuse me, the respondent, the Midland State University of Zimbabwe. So I asked.
Yes,
I asked.
It's very strange.
I asked if he was a respondent. They told me the respondent. So we both go.
So the runner-up team can come to the front, and the judges will hand your plaques and then we can take some photos, and then the respondent, the winner, can join. So the runner-up first, please. Sorry, I was not in control of that. I thought you had the names there, and you had to know which one to go first. The runner-up. I didn't know that there was only one name.
There was only one name.
That's not a problem. Okay. We're going to give them. We just need to give them those score sheets. You have the score sheets, right? So that at least they don't feel like we're doing something on that. So just go and give it to them as you are. No, we don't want to see as a loving flag.
I don't want that.
No flag, no flag, no flag, no flag, no flag, no flag, no flag. So thank you very much. I think, as the saying goes, that's all, folks. But there is also lunch. There's lunch outside. And just to say that we have given also the score sheets to the applicant and respondent team, so they can see the outcomes of the final round. But otherwise, just to once again, I may be giving the last word to Tapiwa to do any administrative arrangements.
All right. Someone always has to have the last word, and that is me today. Your refreshments, please not even try, but use the exit that is on my extreme left. Okay, do not use the first exit there, because you'll not be able to access the food. Okay, if you want to access the food, the door on the extreme left, because you will see when you exit why I'm saying that.
All right. Once they're out, I'll tell them. Okay.